Good morning, everybody. Hey, how are you? I'm waiting for my iPad to catch up so I can mute it. It's not catching up. How was everybody's evening last night? What are you doing? It's still waiting for me. It says, wait, there it goes. Oh, I'm there. Mute. Thank you. This is all I did yesterday. When I got off of here, I watched EDB, and then I watched Peter, and then I watched Runkle. And I didn't glean like any great lawyer insights from Karen Reed yesterday because it was just so delicious. Everybody was just so happy. But I had a very good evening. I diamond painted and I watched all the other lawyers laugh at the cross yesterday from Karen Reed. It was so good. Oh, it was so good. So good morning, Jill. Idaho's back. Yay! Judy, Carla, Terry. Did I miss anybody? Good morning, my friends. It's so good to see you all. This got spicy yesterday. This is outside the presence of the jury. And again, I need to learn some law, y'all. I'm confused because okay, this is the defense's case in chief has started. But this guy seems to be very, very much a prosecution witness. This is outside the presence of the jury. And yesterday we watched the prosecution question this man, and he was security, bodyguard. I don't know what you want to call him. I don't know what his official term is. Yes. Because, yes, Runkle has started calling Buchanan potato. He reminds Runkle of potato. Everybody kept calling him Popeye. And I get why they're saying Popeye. Because Popeye, like, his lips are, like, kind of, like, folded in and his chin juts out. Because his lips... If you look at, like, an old grandpa that doesn't have any teeth, how they're... Rodney's back, too. Hey, Rodney. How their, like, lips go in and their chin juts out. That would be Buchanan if he had a chin. But he doesn't have a chin. Like, he's disproportionate. Like, the top part. We shouldn't make fun of people's appearance. But sometimes they deserve it. I'm sorry. Like, the top part of his face is proportionate. And then, like, it's like God ran out of room. He was doing the bottom part of his face. I'm sorry, Lord, please don't strike me down for that comment. So everybody kept saying Popeye. And Jill keeps saying, he just has a punchable face. But then Runkle said, no. He's not Popeye. Because Popeye's all chin. And Yuri doesn't have a chin. So to me, he looks like a potato. So Runkle started calling him Potato. So anyway, this guy in the Phil Spector trial, he testified yesterday that Phil Spector took a gun with him to Joan Rivers. This guy was security for Joan Rivers. 2 years in a row, Phil Spector took a gun with him to Joan Rivers' Christmas party. Why he was invited back the second year, I have no idea. The first year, he started waving a gun around and screaming that effing see you next Tuesday, I'm going to put a bullet in her head. Like, well, not screaming it, but in a louder than normal voice. I still don't know who the see you next Tuesday he was referring to was. So he takes him out. What is it? Dorothy Melvin? Is that the name of his date? He's been with so many women, which shocks me that I can't keep them all straight. I think that's her name. And so I think that was the next year he did the same thing, same exact words. And the second year, she got the security guy and said, get him out of here. And he put him in the limo or car, whatever it was. And then she got in the car with him, and the security guard was like, are you going to be okay? And she's like, yeah, I'll be fine. I was like, alrighty then. So this is a cross-examination by the defense. Now remember, this is outside the presence of the jury. And I'm confused because the prosecution has already rested their case. So if they let this witness in, like, I don't know why they're even talking to this guy, why it's outside. I get why it's outside the presence of the jury, because they're trying to see if they're allowed to have this guy testify. But why would he testify? Because the prosecution's already rested their case. So, like, this is another one of those times where I need to be a lawyer to understand what's happening right now. Her personal assistant was probably fired for sending that invite. I don't know, because it was like a +1. I mean, his name was on the list, but he was a +1 because he was the date. She was her personal assistant, right? His date was her personal assistant. So that's how he got on the list to begin with. Wasn't that what she was? She worked for her in some capacity. I just don't remember. I'm not taking notes on this trial because it's an old trial and who cares? I am taking notes on Karen Reed, though, except for, when didn't I? I think Jim McCabe. I didn't even, because I literally just wrote down Jim McCabe lies. I was like, what's the point of writing down all her lies? I actually wrote that. Okay, let's get this, because we're not going to get through all of it before Karen Reed starts. They've actually been starting on time, too. Yeah, his date was actually her personal assistant, which is why he got invited in the first place. If I recall correctly, and I think I'm right, but I'm often wrong, so.
Mr. Johnson, as I understand this, you actually, you yourself contacted the district attorney's office around around January 31st of this year. Isn't that correct?
Yes, that was the second attempt I made.
They didn't come to you. You went to them, right?
That's not exactly right.
Well, you recall having an interview with a Los Angeles County Sheriff's detective named Richard Tomlin?
Yes.
And you did reach out to him, didn't you?
Yes.
Specifically on January 31st of 2007, you contacted him, you called him, correct?
Yes.
Okay. And the purpose of you calling him was to discuss some of this story that you've been telling us here this morning, is that right?
No.
Had you ever met Mr. Tomlin before? You hadn't, had you?
No.
So when you contact him on the phone, you talk to him, right?
Yes.
And what you talked to him about is basically what you've testified here this morning. Isn't that true?
Not initially, no, Counselor.
Okay. Did you ultimately have a conversation with him about what you testified here this morning on the telephone.
Oh, yes.
And you reached out to him because you wanted to bring to the prosecution's attention this information that you had. Isn't that correct?
Not at that time, Counselor.
Okay. So why did you call Detective Tomlin at the LASO, Los Angeles Sheriff's Department?
I wanted to know if he was looking for me, if the LADA's office was looking for me.
You had no information before that they were, did you?
If I could explain my answer to you.
Just answer my question if you would, sir.
And the question was?
Did you have any knowledge that they were looking for you?
I had knowledge someone was looking for me. I didn't know who. I first reached out to the defense, and after not receiving any phone calls in return to me from the defense, I then said somebody else is looking for me. It might be the DA, and I called the DA's office, and I asked if they were looking for me.
Okay. And the DA's office had you ultimately interviewed on the phone by Mr. Tomlin, the detective, one of the two detectives assigned to this case, correct?
Oh, I don't know who's assigned to it. I spoke to Mrs. Tomlin.
Okay. You spoke to him over the phone, didn't you?
Yes.
And what you spoke to him about, Mr. Tenaza, was your testimony, basically, that you just given here this morning, correct?
Yes.
All right. So let's talk about that, sir. Prior to taking the witness stand this morning, did you meet with either Mr. Dixon or Mr. Jackson to talk about your testimony? You did, didn't you?
Yes.
Okay. When'd you do that?
Yesterday.
Sunday, correct?
Yes.
Here in this building?
No.
Where'd you meet with him?
At the hotel I was staying at.
Okay. I don't need to know where that is. How long did you meet with him?
An hour or two, maybe.
Was it both Mr. Dixon and Mr. Jackson, or just Mr. Dixon?
Mr. Dixon.
And Mr. Dixon, of course, had somebody with him, didn't he?
No.
He was just by himself?
Yes.
And the purpose of this meeting for an hour or two is basically to go over your testimony, right?
Yes.
In doing that, did he show you a 3-page report that was authored by Detective Richard Tomlin regarding his interview with you?
Yes.
You looked at it, didn't you?
Yes.
May I approach for foundation purposes? Thank you. Mr. Tenaza, I'm going to show you a 3-page report. I just want you to look it over very quickly and tell me whether or not this is the report that he asked you to review yesterday.
Yes.
Okay. May I have it back? Thank you. Now, let's talk a little bit about these incidents. You indicated in your testimony here this morning that it occurred in 93 or 94, correct?
Yes.
Okay. When you spoke with Mr. Tomlin, you didn't tell him it was 93 or 94. You gave him different dates, didn't you?
Probably, if you say so, yes, Counselor.
Okay. If I suggested to you that in his report it reflects that you told him it was in 95 and or 96 or maybe even 97, you wouldn't quarrel with that, would you?
No.
Okay. And you spoke with him this year, right? In January, correct?
Yes.
About 6 months ago, right?
Yes.
But during that 6-month hiatus of time between January 31st of 07 and yesterday when you met with Mr. Dixon, did you speak with Mr. Tomlin again? You didn't, did you?
I might have.
You don't
I'm
remember?
not sure.
All right. Now, as I understand it, on this first incident, and we'll just say somewhere in the 93, 97 era, okay? Is that comfortable for you?
Fine.
Because you're not sure, right?
I'm not.
Okay. So let's talk about the first incident that you testified to, all right? The first time you saw Phil Spector in person, correct?
Yes.
And you recognized him, right?
Yes.
Okay. Basically because you've been a fan of his music. Is that a fair statement? At that time?
Yes.
I think you said he had a couple of his CDs and you
Yes.
knew his music and his reputation, correct, in the music industry?
Yes.
All right. As I understand it, he walked in with his limo driver and he had his keyboard with him. Is that correct?
Yes.
And he went upstairs in the elevator. Is that right?
Yes.
About an hour later, you indicated you're not upstairs, you're downstairs in the lobby, right?
Correct.
And while in the lobby, you get a phone call. Is that correct?
Yes.
And the phone call comes from Dorothy Melvin. Is that right?
Yes.
And court's indulgence for just a moment, please. And you indicated Dorothy called down and spoke to you, is that right?
Yes,
And she said to you, get up here, Phil just pulled a gun out. Is that correct?
yes,
And you're sure it was Dorothy Melvin?
90% yes.
Okay. You remember when you were interviewed by Mr. Tomlin, you touched on this subject as to who made this call?
Yes,
You remember what you told Mr. Tomlin in January of this year, about 6 months ago?
yes,
Okay. Isn't it correct that you told him at that time you weren't sure the caller was Dorothy Melvin? Isn't that what you told him?
that's part of the answer, yes.
Okay. You believed it was her, but you weren't sure, correct?
I told Mr. Tomlin, and I believe it's in that report, that I was 90% sure it was Dorothy Melvin. 100% sure? No. 90% sure? Yes.
The report, you show me in this report where it says.
Oh, I'm sorry,
Hold on,
Counselor.
hold on. We can't talk at the same time.
Okay.
I'm going to show you this report. I want you to show me in this report where there is a statement attributed to you that you say you were 90% sure it was Dorothy Melvin. And just so you can, just so we'll save some time, let me direct you to the paragraph in question, okay?
Yes.
And that's right here. Counsel, paragraph, actually it's paragraph 2 on page 2 at the top, starting with a few hours. Just read that to yourself. Have you read it?
Yes.
It's not in there, is it?
Not Mr. Tomlin's report, no.
All right. As you indicated, the elevator doors open up. You're approximately 8 feet away. It's a little foyer. And you observe Ms. Melvin and Mr. Spector to be engaged in, I think what you said was an argument. Is that correct?
Yes.
And you used the term ranting. Mr. Spector was ranting. Is that correct?
Yes.
You didn't say anything about ranting to Mr. Tomlin when you spoke to him 6 months ago, did you? Regarding this particular point in time in your story. You didn't use that word, did you?
I don't know if I would see my testimony.
Sure. Your Honor, may I ask?
Yes.
Again, paragraph 3 on page 2. Would you just take a look at that and read that to yourself right there? Have you read it?
Yes.
The word ranting does not appear as a word that you use to describe an argument, does it?
Well, objection, that seems to back on evidence that the district.
All he can say, excuse me, all he can say is it's not in the report.
It's not in the report.
All right. Now, as I understand it, your testimony is that Mr. Spector used a phrase, and he used it over and over again. Is that right?
Yes.
And he said, "This fucking cunt," right?
Correct.
And as I understand it, at that point, you made a security decision, which was, in response to Ms. Melvin's request, to have Mr. Spector leave the premises, right?
Yes.
So you escorted him into the elevator, is that right?
We just got in.
Okay, you didn't have to escort him, you just got in the elevator
Yeah.
and down you went, right?
Yes.
And as I understand your testimony, in the ride down in this small elevator, you were next to him, is that correct?
Yes.
And you gave him what you described as a light pat down, is that right?
Yes.
Now, when I say a pat down, you didn't bring your hands along him, his back and his sides and his front, did you?
No.
You just kind of brushed up against him, is that right?
Well, I used my hands also, but I did touch him.
Okay. And that was without his permission, correct? You didn't ask permission to
Oh,
touch him?
no, I didn't ask permission.
Okay. And you determined from the light touch that he had a gun in the waistband on the right side, is that correct?
Not from the light touch. I knew there was something there.
You knew there was something there. You felt an object, correct?
Yes.
Moment in time, correct?
Yes.
Handled a lot of weapons,
Yes.
correct? So from this light touch of this hard object, you determined that he had a weapon on him, is that right?
Not from the light touch, Counselor. After I made the light touch and felt an object, I then put my hand on it and I felt the butt of a gun.
Okay.
And I knew what it was.
Elevator gets down to the lobby floor, the doors open, and you and Mr. Spector and Ms. Melvin walk out, correct?
We walk out, the three of us, yes.
Okay. And then, as I understand it, you are now in the lobby, correct?
Yes,
And in the lobby, once again, according to your statement, repeating again, this fucking cunt, right?
yes,
Same as upstairs, correct?
yes,
Okay. At that point, you start to exit the lobby, is that right?
yes,
Now, you indicated that he made a move towards that, right?
towards his pocket in this direction,
Okay. And is that where you felt this hard object with the butt?
right over it, on the side.
And when you noted he made this move towards his pants, as I think you've described it, you made the statement to him, if you pull out a gun, I'll blow your brains out, correct?
Yes,
Okay. When you met with Mr. Tomlin, you never made any statement about him making any move towards his pants in the area of where you felt the hard object, which you believed to be a gun, did you? You never told him that in January when you spoke with him on the phone.
I believe it's in my testimony, Counselor.
Well, let me show you the report again, I forget. Let me show you the report. I'm going to direct you, Mr. Tenazzo, to the area in the report where you are describing to Mr. Tomlin on the phone this incident. And you tell me, sir, where it says that Mr. Spector made a move towards his pants. And let me direct you, sir, right here. And it would be Mr. Dixon, paragraph 4 and part of paragraph 5. So it's just here and here. If you just read it to yourself. You tell me where in that report it says that you made that statement.
Mr. Tomlin didn't put it in. It doesn't say it.
Didn't ask you.
It doesn't say it.
Thank you. It's not in the report, correct?
It's not in Mr. Tomlin's report, no, Counselor.
You did not make any notes yourself during the time that you spoke with Mr. Tomlin, did you?
No.
You didn't make a report. I mean, you know how to make police reports. You made thousands of them.
Yeah, I didn't make any.
Okay. Now, you said to him, if you pull out a gun, I'll blow your brains out, correct?
Yes,
You told Mr. Tomlin something different that you said to him, didn't you? You told Mr. Tomlin that what you said to him was, if you pull out a gun, I'm going to blow your fucking brains out. That's what you said. Isn't that true?
I believe my words were, if you pull out that fucking gun, I'll blow your brains out. Or I might have said, if you pull the gun out, I'll blow your fucking brains out.
Okay. So you don't quarrel with the fact that you told
No,
him to talk.
I don't quarrel with that at all.
And as I understand it, Mr. Spector gets into the limo. You get in with him. Is that right?
Yes.
Did you use the phrase that you threw him in the limo? Is that correct? Isn't that what you
he
just
got in.
Didn't you just say you threw him in the limo?
That was the second incident, I
All
believe.
right, we'll get to that in a moment. Thank you. And you sent the bodyguard off for the keyboard, correct?
The limo driver.
The limo driver. You then indicated that Mr. Spector showed you a badge that he described as one which showed that he was a sheriff in North Carolina and that he took out a pistol permit. Is that correct?
Yes,
Okay. And you remember that very clearly, correct?
Yes.
Just like you remember the rest of this incident, correct?
yes,
Okay. Again, court's permission.
Yes.
Show me where Mr. Tomlin's report it says that he showed you a badge, told you he was a sheriff in North Carolina, and in addition to that, also gave you a piece of paper, presented you with a piece of paper saying that this was a permit. It's not in there, is it?
not in Mr. Tomlin's report, no.
Okay. By the way, the limo driver returned. Is that correct?
Yes,
He had the keyboard, is that right?
yep.
He got in the car. Correct.
After putting the keyboard in the trunk.
Yes. And they went on their way, is that
Yes.
correct? You remained, right?
Yes,
You never saw any weapon that day, did you?
no,
And you never saw Mr. Spector with a weapon in his hand, did you?
no.
You also indicated that Mr. Spector made a statement, quote unquote, everywhere I go, I carry a piece. I direct your attention, sir, to paragraph 6.
Hold up. He just said he didn't see him with a gun. I thought he said that he took a gun out and was waving it around. Did I misunderstand? Did he just threaten to pull out a gun? Okay, maybe I misunderstood. Because I thought he said he took a gun out and said that effing see you next Tuesday, I'm going to put a bullet in her brain. So maybe he just threatened to pull out his gun. And I misunderstood. But still, that's bad enough. Especially when you actually do it to somebody.
Which starts with Tanazo said. Ask you to look at that and tell me where that statement appears in that official Los Angeles County Sheriff's report. Doesn't.
No.
Okay, let's turn to the second Christmas party. This was about a year later, is that right?
1 year to the date, yes.
Okay. And you were serving in the same capacity as security for Miss Rivers at this Christmas party, correct?
Yes.
Okay. And you looked at the guest list when you arrived early and you saw Mr. Spector's name, correct?
Yes.
And as I understand it, Mr. Spector arrives, you permit him to enter, you permit him access to the party, and up he goes in the elevator, right?
Yes.
Okay. As I understand it, about 1 to 2 hours later, you saw him again, right?
Yes.
And when you saw him, he was in the lobby with Miss Melvin, right?
Yes.
And he and Miss Melvin were walking out and they were talking according to your direct examination. Isn't that right, Mr. Tanazo?
They weren't. They were arguing.
They were arguing. Mr. Spector once again was saying, that fucking cunt, that fucking count, in a loud manner. Is that correct?
Yes.
And Miss Melvin responded by saying, Vinny, put him in the car, correct?
Well, as that was going on, I got between them and she said something, maybe get him out of here or put him in a car. Yes.
Okay. Now, you didn't get between them because you heard Mr. Spector threaten Miss Melvin that evening at all.
No.
As a matter of fact, you got between them as a security measure because of your prior experience with Mr. Spector, not because of anything that was going on between he and Miss Melvin. That's a fair statement, isn't it?
Yes.
Okay. And as I understand, while you were in the lobby with Mr. Spector and Miss Melvin, the elevator comes back down again and the door's open. Is that right?
Yes.
And when the door's open, somebody steps out, correct?
Yes.
And they step out into the lobby, right?
Yes.
And that person is a female, correct?
Yes.
No question in your mind it was a woman, right?
Oh, yes.
And when the woman steps out, Mr. Spector looks in her direction. Isn't that true?
Yes.
And Mr. Spector states, that fucking cunt, I ought to put a bullet in her head right now. That's what you testified to, correct?
Yes.
He and Miss Melvin then left, isn't that right?
Yes.
And when he and Miss Melvin left, that was the last you saw him, correct?
Yes.
You never saw a weapon in Mr. Spector's hand that evening, did you?
No.
And you never gave him a hard pat down, a medium pat down, or a light pat down, correct?
No pat down at all.
So you had no reason to believe he was armed that night, correct?
That's correct.
Court's indulgence for a moment, please. Mr. Tanazo, Mr. Dixon very adroitly drew out of you the fact that you have some lengthy law enforcement experience, correct?
Yes.
You're quite familiar with the Sullivan Law in New York, aren't you?
Yes.
Okay. Without getting into great detail, basically what it says is no individual other than law enforcement is allowed to have a weapon on them in the city. Isn't that right?
If you say so, counsel, yes, I agree with you.
Okay. Did you have Mr. Spector arrested on the incident regarding the first Christmas that you testified to? You did
no.
not.
No.
And you didn't have him arrested the second incident, correct?
No.
Yet you felt a hard object in his waistband that you touched with your hand, believed it to be the butt of a handgun, and were satisfied based on years of experience and your years of working with a handgun that he in fact was armed, correct?
Absolutely, yes.
And you didn't call the police and have him arrested under the Sullivan Law, did you? You didn't.
You don't have him arrested under the Sullivan Law.
I didn't ask you that. I asked you, did you call the police and have him arrested for carrying a concealed weapon in violation of the Sullivan Law? It's just yes or no.
I can't answer that in a yes or no, Counselor.
Go ahead and explain. If you didn't, why not?
Your Honor, when he says the Sullivan Law, it's a penal code number for carrying a concealed weapon. Number one, I didn't have a complainant.
Well, you didn't need a complaint. You were a former law enforcement officer.
Check's on. Let him finish the answer.
Sure.
And you can follow.
Sure.
Go ahead.
I didn't have a complainant to make an arrest, number one. Number two, at that time, I didn't know if he was legally allowed to carry a gun or not. And I felt that situation, just to get him out of the premise.
Mr. Tenazzo, how many years did you work for the New York Police Department?
17?
17, almost 2 decades, right?
Yes,
You made many arrests for people carrying concealed weapons in violation of the law, correct?
yes.
It's a victimless crime, isn't it? You don't need a complainant. All you need to do as a police officer is determine whether or not somebody is possessing that weapon without lawful authority. And if they have, then they have violated the penal code section of carrying a concealed weapon. End of case, correct?
No,
Why do you need a complainant then, sir?
no, what you just said, Counselor, the way I understand it, you just don't walk over to anybody, and if you feel a gun, just say you're under arrest.
No, that's not what I mean.
Well,
Sir,
that's what I understood it to say, then I'm sorry.
It was probably my fault. Mr. Tenazzo, you made many arrests for carrying a concealed weapon for the 17 years that you were in the New York Police
Yes.
Department. When you did that, some of those cases wound up going to court, correct?
Yes,
You went to court and testified as a witness, correct?
yes,
You testified to the weapon being on the person, correct?
yes,
Because you were a police officer and had law enforcement experience, you knew that carrying a concealed weapon is a crime in itself. You don't need a complaint to be in violation of that penal code section, correct?
Counselor, again, I can't answer that yes or no. When I made what they call gun collars, 9 times out of 10, we either witnessed the action or had a complainant to say to me, that guy's got a gun or something. I just didn't walk up to someone randomly and say, you got a gun, you're under arrest. It doesn't work that way. But if it's pointed out to me that someone has a gun in whatever situation is, then I would take the appropriate action.
But there were various instances when you were a police officer, when you yourself would stop somebody for what you believed to be unlawful activity.
That's irrelevancy. Police officer, he wasn't a police officer.
Mr. Rosen, I think you made your point. Okay, you can move along.
Very well. Court's indulgence for just one moment, please. Just 2 quick points. You never saw any aggressiveness other than bad language by Mr. Spector towards the woman at the first Christmas party, correct?
No, I never witnessed anything about the first Christmas one.
Okay, and at the second Christmas party, Mr. Tenazzo, the same question. You did not witness any aggressive action by Mr. Spector towards that woman either. It was only bad language, correct?
That's not correct, Counselor.
We're talking about the second Christmas party.
That's correct, Counselor.
Okay, this is the one where you saw the woman come out of the elevator. Mr. Spector turned and started ranting at her, correct?
He started to walk towards her as he was ranting.
Okay, and you stopped him.
I stopped him.
Very well. Thank you. Nothing further.
Thank you. Redirect.
Mr. Tenazzo, a number of the questions Mr. Rosen asked you, he walked up and showed you a 3-page report that apparently Detective Tomlin made as a result of your interview with him. Is that correct?
Yes,
Now, in the materials that you reviewed prior to testifying, you had that report, right?
yes,
But you also had a transcript of the conversation that you had with Mr. Tenazzo, or excuse me, with Mr. Tomlin. Isn't that right?
yes,
In fact, your conversation with Detective Tomlin was tape recorded, and you reviewed that transcript of that tape, correct?
yes,
Did it appear to be correct to you?
yes, it did.
And although Detective Tomlin's report of your interview was only 3 pages, rather short, the transcript was comprehensive as to your conversation with him, right?
Yes,
Now, Mr. Rosen asked you, well, there's no comment in Mr. Tomlin's report about you saying that the defendant was ranting and raving and carrying on. Didn't he remember that question?
Yes.
Counsel, page 7 of the transcript. Let's see, I'll keep the lines 12 through 16. Mr. Tenazzo, do you remember in that transcript during your interview with Detective Tomlin telling him, with respect, I think, to the first Christmas party, Tenazzo, okay, the elevator door opens up. I walk out of the elevator with him, Spector, Dorothy, and we're walking into the lobby. He's ranting and raving and carrying on. Every other word out of his mouth is this fucking cunt. Do you remember saying that?
Yes.
And in fact, that's what happened, right?
Yes.
Now, the fact that it wasn't in the report, it's in the transcript of the interview, correct?
Yes, I gave my
And that's what you,
testimony to Mr. Tomlin.
right. Now, Mr. Rosen also asked you about the badge from North Carolina. Remember?
Yes.
And he said, he walked up to you and he showed you the report. He said, well, there's nothing in this 3-page report by Detective Tomlin that says that you told him that the defendant had this badge from North Carolina. Remember that?
Yes.
Okay, well, inviting counsel to page 9, this is lines 20 to 23. Do you recall telling, pardon?
Bait stamp number.
Well, I don't have the Bates staff copy, but you have the transcript. It's page 9 of the transcript, lines 20 to 23. Okay. Do you recall telling Detective Tomlin at that time, quote, and that's Spector, he pulls out a badge. He shows me a badge and he says to me, listen, I love cops. I'm a sheriff from North Carolina and this and that, and he's ranting and raging on. Do you recall telling Detective Tomlin that?
Yes.
Even though it wasn't in the 3-page report, again, it's in the transcript of the interview, right?
Yes, I had no control over Mr. Tomlin's report. That's my testimony.
Okay. And just one or two more. Mr. Rosen asked you some questions about when the defendant told you about permits for guns all over. And again, I think showed you Mr. Tomlin's report and asked you to find that comment in his report, and you said it wasn't there. But again, you told him that in your interview, your tape-recorded transcript interview, correct?
Yes.
And inviting counsel to page 10 of that same interview, lines 17 to 23, let me ask you if you recall telling Detective Tomlin this. And he keeps repeating it. He tells me that's why I got permits for all over. Wherever I go, I always keep a gun because these fucking cunts, they're all no fucking good. And this is why he's carrying on for 10 minutes. And finally, the guy comes with the keyboard, puts it in the trunk, and they're gone. Do you recall telling Detective Tomlin that?
Yes.
In fact, the defendant, once you were in the back of that limo with him, waiting for the keyboard to return from the party, he wasn't ranting about just one woman, but all women. Isn't that right, what he was saying?
Yes.
All the women, all these C words deserve to die. Isn't that right?
Yes.
Now, last couple of questions. Mr. Rosen was asking you a couple of questions about how you were contacted by the DA's office, and I think you were trying to explain, so I'm going to try to give you that opportunity. You thought somebody from the defense called you?
Yes.
Why?
I came home one day and it was a message on my machine. And the message stated, Vincent, and they started to say my last name and it came and broke in. But what I made was, this is in regards to the Phil Spector case. And that's all I got from the message. And being an ex-detective, I wanted to find out who was looking for me in this case. And I had contacted Joan Rivers' people because I had found out a month previous that the defense team tried to get a deposition from Ms. Rivers. and she was contacted by the defense team.
Ross would object to that, move to strike all. That would all be hearsay.
It goes to his state of mind as to what he was trying to do. The objection's over. Go ahead.
Please continue.
More of your answer.
Yes.
Go ahead.
And I got 3 telephone numbers, and I dialed all 3 numbers trying to get a response. The first number I called was a former FBI agent who's now a private investigator who was working for Mr. Cutler. And I finally got him on the phone, and I said to him, my name's Vinny Tenazzo, are you looking for me? He said, no. I had a second name, and I asked him about the second party. And he said to me, no, I know him. He's also retired FBI. We no longer are with the case, and we're not looking for you. I then placed 3 phone calls to Miss Barton's cell phone and left her 3 voicemails and got no response. And then I think I made a 4th call, and there was an option where push a number, and instead of leaving a voicemail, I put in my home number for her to contact me, and I never heard anything. So I figured my name is out there, no response from the defense, so then I called the DA if you guys were looking for me. That's how it came about today.
So the bottom line kind of is that you thought initially the defense might be trying to locate you as a possible witness, and you tried to respond to them.
Oh, absolutely, yeah.
And when that apparently wasn't the situation, then you called Los Angeles law enforcement.
You were my second choice, yes.
Thank you. Thank you. Nothing further.
Thank you. Read the request.
I don't know what choice I was, but you didn't call me. Mr. Tenazzo, as I understand this, you worked for Joan Rivers for security for some time, correct?
Yes, sir.
All right. And I assume that you informed Ms. Rivers of what occurred with Mr. Spector. Is that correct on that first instance, either 93, 94, 95, 96?
No, I didn't.
You didn't tell her?
No.
Okay. Did you tell her about the second instance?
No.
Okay. Just one other question. The partial message that you got on your machine, which I think you said all you picked up was in regards to the Phil Spector case. That's all you were able to.
I got Vincent and then something with Phil Spector on it. And when I hear Vincent, I go, oh, because.
Most people call you Vinny.
Exactly.
All right. So you just assumed that it was the defense trying to contact you, correct? Based just on Vincent in regards to the Phil Spector case.
Yes, and plus the fact that the reason I assumed that, I had known that the defense was trying to get a deposition from Joan Rivers, so I thought they were looking for me next.
When did you have that partial call listened to that was basically Vincent in regards to the Phil Spector case? When was that?
Maybe a week before I contacted the district attorney's office.
Okay, so it would have been like mid-January of this year, is that
I
correct?
guess, yes.
Okay, thank you very much. Nothing further.
Thank you. Redirect.
No, thank you, Your Honor.
All right, thank you.
Further at this time.
Thank you. You may step down. I think you're going to need to wait in the hallway, but you can step down right now. Thank you. Argument, people?
Your Honor, very briefly, the court has read our moving papers initially. We maintain that the arguments that we set forth in the moving papers are the same arguments that we would present now. In brief, basically what Mr. Tenazzo's testimony does with regard to this trial and the facts of this trial, and as the court duly noted the week before last, now that the court has had an opportunity to fully absorb the complexion of the case, both from the prosecution and the defense side, at least through cross-examination, at least through the first couple of witnesses. The suggestion is that Ms. Clarkson, by the defense, Ms. Clarkson walked into a complete stranger's house and killed herself. The prosecution's evidence is very much in opposite of that. The evidence is very clear that Ms. Clarkson went voluntarily with Mr. Spector to his home that night, that Mr. Spector had certain ideas in mind. That evidence is suggested by the dim lights, the candles, the music playing, the fact that he was alone with her in his house, the fact that he offered her alcohol, and she probably consumed or had to have consumed alcohol, the fact that he likely was consuming alcohol at the house, as well as having consumed alcohol throughout the course of the evening, and the fact that he took Viagra pills, or at least the suggestion is that he took Viagra pills. He had pills in his possession, some of which were missing. in his valise, or his valet rather. This is circumstantial evidence about what happened next. The big question is, what happened? How did Mr. Spector react to Ms. Clarkson with regard to possible advances that he made toward her? Well, we know what the circumstantial evidence is. She got up, she put her purse on her shoulder, she had her jacket on, and she walked or moved toward the back door. She was seated some 8 feet from the back door, 12 or 14 feet from a waiting limousine, obviously, very obviously, ready to leave. Mr. Spector doesn't react well when he is not in control. Mr. Spector has a very particularized reaction, and his state of mind goes into a very focused nature when he doesn't get his way. He obviously wasn't getting his way. So all that combined with Mr. Tenazzo's testimony is powerful circumstantial evidence as to what Mr. Spector's state of mind was, which is relevant in this case, and how he would have acted and reacted toward Lana Clarkson's conduct, and possibly reacted toward a sexual or romantic rebuff by Ms. Clarkson, all of which is circumstantial evidence that can be argued before this jury as the case stands right now. That's why we asked for it to be put in our case in chief. Understandably, the court didn't have as much information as it now has. I think given the complexion of the case, Mr. Tenazzo's testimony is extraordinarily relevant, and it certainly is not outweighed by any prejudicial value or prejudicial effect that Mr. Spector would suffer. The probative nature of the testimony far outweighs any prejudicial effect. We would ask that he be allowed to testify basically consistent with his out of the presence testimony here today.
Thank you. Mr. Rosen.
Thank you, Eric. Mr. Jackson's argument is a sweeping general argument, but let's get back to the law on this. And if we get back to the law, we start with two propositions that the government asserted to this court as to why it should be allowed. First of all, they filed in their renewed motion 7 pages that they had lifted from the daily transcripts indicating that I had opened the door to this by questioning Kathy Sullivan, Rami Davis, Jennings, Ogden Halder, that was Mr. Cutler, Stephanie Jennings, Melissa Grosvenor, and Dorothy Melvin. They indicated that because I took the initial step ab initio by questioning in this area about the good traits of Mr. Spector, the defense made a boo-boo. We erred and we opened the door. That's not what the record states. I spent my Sunday going through the record. And in fact, it was Mr. Dixon and Mr. Jackson, both, who asked questions of 1, 2, 3, 4, 5 of these witnesses long before they were turned over to me for cross-examination. Excuse me. And they elicited some testimony, which I think the court might find interesting, to prove that point 1 of their renewed motion is dead wrong. Dorothy Melvin, daily transcript page 1344, line 6, direct by Mr. Dixon. Answer, she found Mr. Spector to be very charming, very attractive. Page 1375, line 28, further direct examination by Mr. Dixon, eliciting the answer that Ms. Melvin found him to be very charming and very attractive. Ms. Ogden Halder, another direct by Mr. Dixon, page 1950, lines 10 through 23. He was a perfect gentleman all the time. Ms. Jennings.
That is code for he could help advance my career. That is what that means. Because he is neither charming or attractive. I don't know. He could be charming, but attractive, no.
Another direct by Mr. Dixon. Pages 2307, line 16 to page 2308, line 15. I found Mr. Spector to be very charming, quite witty. Ms. Davis, Rami Davis, not one of the 1101Bs, but the lady that he started the evening with. Another direct by Mr. Dixon, page 2410, lines 19 through 23. Mr. Spector was bright, interesting.
Rami wasn't even romantically involved with him. She was just a friend.
Very fun person to go to dinner with. And finally, Kathy Sullivan. And this is a direct by Mr. Jackson. Page 2453, lines 6 through 19. We had fun. Page 2454, lines 11 through 14. The witness, Ms. Sullivan, and Spector developed a friendship, a good friendship. page 24, line 55, page 2455, line 25 to 2456, line 7. We were platonic friends, good platonic friends. And finally, at page 2589, lines 9 through 19, he was very father-like. All of these sites were elicited not by me. Long before I had these witnesses on cross-examination, they were elicited by Mr. Dixon and by Mr. Jackson in combination on their direct examination. First point. Second point. The second point is, and this is really the theme, it is the thread that runs through the tapestry of both their argument in the initial motion that they filed back on April 3rd, which the court denied, and we're going to ask the court to deny it again, and then on June 21st. Their theme, their theory, which I noticed Mr. Jackson did not address in his arguments to this court, and I know why he didn't address it. Because the theme and the theory and the thread that runs through the cloth of all of their argument is that because he made these generalized statements in the lobby, because he made these generalized statements in the back of the limo and upstairs about women in general, it shows that they should be permitted so that they can prove motive and intent by Mr. Spector towards Ms. Clarkson. Your Honor, here was the testimony here this morning, and you heard it. It was not a generalized ranting and raving. It was anything but that. Regarding the first Christmas party, here's the statement. In the lobby, allegedly, Mr. Spector said, "This fucking cunt," repeating it again, "this fucking cunt." Not all the world of women. Also, in the second Christmas party, a year later, when the woman specifically walks out of the elevator, "That fucking cunt, that fucking cunt." And Mr. Tenazzi even said he started to walk in her direction, and he stopped. His testimony alone here this morning undermines completely the government's theory. They are trying to bridge that chasm from a generalized...
No, because then he goes on to say all of them, all of the effing see you next Tuesdays. And that's why I have permits for all over the place so I can carry. Did he not say that? Did he not say that? Dude, you're burying the lead. Of course, because you don't want them to know it.
Which did not take place because now you have heard the testimony. It was specific, although 365 days apart at the holiday season, to Ms. Clarkson. And therefore it doesn't work. It doesn't show motive and intent on the evening in question or the morning in question. And the other final thing is it sounds to me that really Mr. Jackson's argument was more of a summation than it really was putting forth the points in their moving papers, indicating to the court that it's already in there. But there's one other point that's very important, and that is this. The court in its ruling specifically stated, and I know you know your ruling, I know you've read your ruling, but I think for the record, it's important to restate it. And that is, and I'm quoting, and here's your words, Judge. Again, depending, for instance, and this is a pure hypothetical situation, if, condition 1, the defendant were to get up, he hasn't, or 2, other witnesses were to testify during the defense, they haven't, skipping, then it might be a different story. The prosecution in their argument in the renewed motion bastardized your words of "it might be" into "it is admissible." That's not what you said. I went back and read the transcript. You never said it would be admissible. They argued that. What you said is it might be a different story. We'll have to wait and see. And finally, the idea that this can be sanitized and cleaned up, again, although not directed or addressed by Mr. Jackson this morning, I feel it of great import to say, as you said before, the whole crux and the whole context of it around that one word which you indicated, and I think correctly so, is so offensive to some people that it's just highly prejudicial, which brings in the 352 argument. And quite honestly, Your Honor, as Mr. Brunman said to me this morning, what it really is character assassination. That's all this is. They've got what they want in. They've got it in through the 41101Bs, and actually they got some of it in a little bit through Ms. Davis. This is cumulative, it's character evidence, it should be excluded under 352. You made the right ruling before. The defense is going to ask you to embrace that ruling now and once again deny the request.
Anything final?
Very briefly, I find it interesting that Mr. Rose knows what I was trying to argue and what I wasn't trying to argue better than I do. He suggested that the reason that I didn't argue this in my initial statements to the court are because I can't prove that the statements by Mr. Spector were generalized, that it was generalized toward not only a woman in particular, but women in general. Mr. Rosen was here when Vinnie Tenazzo was testifying 45 seconds ago. He heard it all. And what Vinnie Tenazzo said was, and this was right out of the transcript when Mr. Dixon asked him on redirect. And then Mr. Spector, proceeds to start these fucking, and I apologize about the indelicacy.
We all do, we understand.
And I'm sorry, Judge. These fucking cunts in plural, not that person, but these fucking C words, plural, over and over and over. And it's 5 or 6 times in here, and I'll reduce it to a single statement. He goes on, and he keeps going, these fucking cunts, plural, they all deserve to die. And he says, they all deserve a bullet in their fucking head. That's not particularized to one woman. And I don't know how Mr. Rosen could have missed that or that could be mischaracterized. It's not. It is a generalized state of mind that the defendant has toward women in general. It shows a misogynistic state of mind that it speaks volumes about how he feels about women. And then we fast forward that and put these statements in context into the foyer at 1700 Grandview Drive, and it sheds incredibly probative light on what Miss Lana Clarkson suffered at the hands of Philip Spector. She fits the category that he, according to his own words, not words that we've put in his mouth, not words that Mr. Tenazzo put in his mouth, words that Mr. Spector chose to use himself in public in front of witnesses. It puts a true context into what he felt about Lana Clarkson. She is part of this category that he despises. He goes on to say, they all, quote unquote, they all, and he tells me that's why I've got permits for all over. Wherever I go, these fucking C words, plural, they all fucking no good. It goes on and on and on. I'll spare us the indelicacy of stating it over and over. The reason that I didn't state it before, and Mr. Rosen says, well, I know why Mr. Jackson didn't state it, because it's indelicate. It's difficult to hear. But the court should also know that under Stephanie Jennings' testimony and through the tape recordings of Mr. Spector's own words, that word is already, indelicate as it may be, it's already in the record. It's not like he's going to suffer more prejudice because the jurors are going to find out that he has used the C word in the past. They already know that. They've heard it, and they've heard it right out of his mouth. This is not overly prejudicial, and it's incredibly probative as to his state of mind. And I'll submit, I think the court knows, based on the former production of the People's Moving Papers, what our position is. Thank you for your time.
All right. I view this, it's a legal issue, and I view it as such. And in doing so, when the motion was refiled, I went back and I read what Mr. Tenazzo was going to allegedly testify if he was allowed to testify. And I'll be quite candid. When I read it originally, I don't know whether I was caught up in what we will refer to. I'm not going to say that in court and go home and talk to my wife about it, so I'll just call it the C word.
Yes.
Okay. She watches these telecasts, so I'm not going to do that. I read it originally, and I saw it as sort of a rant from someone who was very angry, just a generalized rant against women. And because of the 352 issues, which we've talked about, I decided to keep it out. When I went back and read it a second time, and I don't know whether I read it the first time and perhaps it didn't register, perhaps I misread it when I read it the first time, the words that struck me, the words that specifically got my interest and why I wanted to hear from Mr. Tenazzo. First, I wanted to find out if he had superficial credibility. What I mean by that, we've all heard, people make offers of proof and then they come into court and they have no credibility whatsoever, or whether, that happens on occasion. And if that had been the case, we wouldn't be going forward. So I at least wanted to find out. And when I say credibility, it's the jury's, ultimately, if Mr. Tenazzo testifies, they'll determine his credibility. But I wanted to make sure he at least had a baseline to go from. And there's nothing that
I know we're late for Karen Reed, but I want to hear his decision.
I've seen today that would make him not a credible witness, but I'm not making any final findings as to that because that's not my function in these proceedings. The words that struck me, and for some reason I read them and I said, was that in the original motion, were the words that talked about shooting somebody in the head. And for the life of me, I don't remember reading it the first time. Now it was there. It was clearly in the motion. Whether I overlooked it and getting, because I was sort of looking at the overall thing, having now heard the testimony, what it comes down to me, there's two issues. There's the 352 issue, and then there's the issue which no one has addressed today, but it's there and I have to consider it. These events took place somewhere between either 93 and 94 or 95 and 96, which means the most favorable interpretation to the people is that these words were uttered 7 years before the incident in this trial. The cases that were cited by the people and also by the defense, and I've gone back and I found other cases that have to do with a state of mind. And that is where an individual who is later charged with a crime, and it's always been murder that I've read, makes a statement at an earlier time about an intent to act in a certain way and then acts in that way. And it has been held to be admissible as a declaration of the defendant's state of mind and a willingness to act that way in the future. Several of the cases that I read, it's not the central piece of the holding of any of those cases. They talk about, when evaluating whether it was admissible, one or two of the cases, perhaps more, have used the language and have stated it happened near the time of the incident that is being charged. In other words, why the trial is taking place. And the greatest concern that I have is that a prohibition? Is that simply something that they stated? How does that fit in with the facts of the case? And I've been very careful, and that's one of the reasons originally I kept it out in the beginning. I've reread all the cases. I've read more cases than I started out with. And the way I analyzed this entire problem, if you will, that has to be gone through and solved is, first of all, Mr. Tanazo, as I said, has when I say superficial, at least he has enough credibility to go to the jury. So the question is, it's up to the jury to believe whether Mr. Spector made these statements or not to Mr. Tanazo, and then assuming that he made them, what relevancy they have to this particular case. And what I find is it's extremely strong when someone says, and whether you take it as a particularized statement against the individuals who roused his ire in these two incidents, or whether you take it, as Mr. Tanazo did, as a statement against women in general. When an individual states, these women, this is the way I think I'll solve the problem, I'll shoot them in the head. They should be shot in the head. And in this case, you have a woman who was shot in the head. That's highly particularized. It's extremely probative. I am concerned with the 352 issues of the use of that word. The jury has heard the word. It also tends to show the depth of Mr. Spector's anger when he uses that word. So I've considered the 352 issues. I have considered the timeliness or staleness of the time of the comment. Given the state of the law, it is not, there is no prohibition against using it. I recognize, and I have considered it continually, because this incident took place years before. These incidents took place years before the incident in this case. But I am satisfied that it is admissible evidence and that the probative value outweighs the prejudicial value, and I will allow the people to present it. And that's my ruling. Let's take a break, give Cindy a chance, and in about 10 minutes we'll resume and we'll start with the jury. Thank you. I don't know when the people intend to present this.
Okay, now we're going to go. Dang, I forgot to set up a portal. Shoot. Let me do it real quick. We'll get caught up, y'all. Don't worry. I promise. Oh, I saw a picture of Brian Albert and Brian Higgins, and I got all excited. That's Vinnie Politan Investigates. It's not the trial. I got all excited. Okay, portal is all set up. If you're not going to Karen read with us, I will see you in the morning. No, tomorrow. Oh, it's the weekend. Have a great weekend if you're not going with us to Karen Read, and I will see you on Monday. If you're going with us to Karen Read, I will see you in a few minutes. I'm not responsible for any injuries or loss that happens in the portal. I will see you over there. Bye.